Breaking news out of California's Attorney General office. Rob Bonta just filed a petition asking the federal court to reconsider its January 2nd decision that struck down California's open carry ban. This is not a routine legal move. This is an emergency filing that could completely reverse the victory gun owners just achieved, and it happens while most people aren't paying attention. On January 2nd, the Ninth Circuit Court of Appeals ruled that California's prohibition on open carry in urban counties was unconstitutional. That ruling meant 95% of California's population could now legally apply for permits to carry firearms openly. It was a stunning defeat for the state, but attorneys in the California Attorney General's office didn't accept the loss quietly. They filed what's called an Banc Petition, which means they're asking the full court of 15 judges to reconsider the decision instead of just the 3-judge panel that ruled against them. Here's why this matters. When a 3-judge panel issues a decision, that panel is bound by precedent established by full court rulings. But when you petition for an en banc rehearing, you're essentially asking the entire court to restart the analysis from scratch. This is a powerful legal tool, and it's used strategically when a panel's decision conflicts with broader precedent or when the stakes are extremely high. California is using it now because they view the open carry ruling as catastrophic for their gun control agenda. The state argues that the 3-judge panel misapplied the Bruen framework by not properly considering California's historical tradition of restricting open carry to rural areas. California points to laws dating back to the 1800s that distinguish between urban and rural zones. The state contends the panel ignored evidence showing California has a consistent historical tradition of denying open carry in populated counties based on public safety concerns. They're saying the panel got the history wrong. Gun rights groups counter that California is essentially relitigating the same arguments they already lost. They argue the historical evidence doesn't support California's preferred narrative. They point out that the panel's decision was well-reasoned and didn't misapply Bruen. The panel carefully examined California's historical claims and found them wanting. They're urging the full court not to grant the en banc petition and to let the ruling stand. The deadline for California to file this petition was January 16th. That filing happened just days ago. Now, the Ninth Circuit has 30 days to decide whether to grant the en banc rehearing. If they grant it, the open carry victory doesn't go into effect while the court reconsiders. The ruling gets essentially frozen. If they deny it, the ruling stands and Californians can start obtaining open carry permits immediately. This is a critical moment because the Ninth Circuit's decision in Baird versus Bonta has created what's called a circuit split. The Second Circuit, which covers New York, Connecticut, and Vermont, has previously upheld restrictions on open carry and required people to carry concealed instead. Now, the Ninth Circuit is saying the opposite. When circuit courts disagree on fundamental constitutional issues, the Supreme Court often steps in to resolve the conflict. California's en banc petition might be an attempt to prevent the Supreme Court from taking the case by having the full Ninth Circuit reverse the panel's decision before the High Court even gets involved. If the full Ninth Circuit upholds the panel's decision, expect immediate legal challenges to open carry restrictions in New York, New Jersey, Maryland, and Massachusetts. Each of these states has similar laws that restrict open carry in populated areas, and each would suddenly be vulnerable to constitutional challenge based on the Ninth Circuit's reasoning. That's why California is fighting so hard to overturn this decision. California's petition is strategically important for another reason. If the full court grants the en banc petition, they could issue a much more sweeping opinion than the 3-judge panel did. The panel's decision was narrow and focused on Bruen's text and history framework. The full court could potentially write an opinion that goes much further in restricting gun rights generally, not just on open carry. They could establish broader principles about how to interpret historical precedent in ways favorable to gun control. Gun rights organizations like the Second Amendment Foundation are already preparing to file amicus briefs opposing the en banc petition. These are friend of the court briefs from interested parties. They'll argue that the panel's decision was correct and that granting the petition would undermine the Supreme Court's Bruen decision. They'll also argue that California's historical evidence doesn't actually support the state's current restrictions because most of those historical laws were enacted during periods of racial discrimination designed specifically to disarm Black citizens and other minorities. The next 30 days are crucial. If the Ninth Circuit denies the en banc petition by late February or early March, open carry in California becomes immediately available to qualified permit applicants. Gun owners could start applying for open carry permits and exercising their rights in urban counties. If they grant it, there's essentially a do-over, and the legal victory disappears while the court reconvenes and rehears the case. This creates uncertainty for California gun owners who have been waiting for this opportunity for decades. What makes this particularly significant is that California's petition signals desperation on the state's part. They didn't just lose a case, they lost a case that affected 95% of the state's population. They're now asking the court to overturn its own panel's decision. That's a high bar to meet, and California seems to think it's worth trying anyway. That tells you how serious the state takes this issue and how threatening they view the open carry victory. The broader constitutional stakes remain enormous. If Baird versus Bonta stands, it doesn't just affect California. It establishes nationwide precedent that states cannot absolutely ban open carry in urban areas based on public safety concerns alone. They would need historical precedent showing that exactly that kind of regulation existed in America's founding era, and California can't demonstrate that. So the panel's decision stands for the proposition that blanket open carry bans in cities are unconstitutional. The Supreme Court is watching this case closely too. If the Ninth Circuit reverses the panel through an en banc decision, it would signal that courts can narrowly interpret Bruen and still uphold strict gun regulations. But if the Ninth Circuit affirms the panel, it signals that Bruen is being applied aggressively to strike down regulations nationwide. Either way, the Supreme Court may eventually take the case if further review is necessary to resolve the circuit split. For gun owners outside California, the stakes are just as high. This case will determine whether your state can maintain open carry bans in cities. If Baird versus Bonta stands, you have ammunition for legal challenges to similar laws wherever you live. If California wins the en banc petition, gun control advocates get breathing room to defend urban carry restrictions through historical re-narratives. The next 30 days will show whether California can convince the full Ninth Circuit to reconsider. If they can't, open carry in California cities is effectively settled law, at least in the Ninth Circuit. If they can, we're looking at months more litigation and uncertainty. Either way, this case represents the front lines of Second Amendment jurisprudence in 2026.